Defenses to formation or enforcement. The following are defenses to contract formation or enforcement. If established, a court may choose not to enforce an otherwise valid contract, or it may be void or voidable by parties. 1. Incapacity, where one or both parties lack capacity to enter into a contract. 2. Statute of frauds. Contracts are subject to statute of frauds that fail to meet the statute of frauds requirement are invalid. 3. Illegality. Subject matter or purpose of contract is illegal. 4. Misrepresentation or fraud. Contract that is formed based on fraud or misrepresentation. 5. Duress. Contract that is induced by force, coercion, or duress. 6. Unconscionability. Contract that is unfair or oppressive to one party. 7. Misunderstanding, where there is ambiguity concerning terms of a contract. And 8. Mistake, when one or both parties are mistaken concerning the underlying facts of a contract. So, incapacity, infants and mentally incompetent persons lack capacity to contract. Intoxication, intoxicated persons may lack capacity to contract if the other party has reason to know of intoxication. Right to disaffirm, persons who lack capacity to contract, such as an infant, may disaffirm the contract, which renders it void. Infancy exceptions. Contracts involving minors may be enforced or otherwise recognized where implied affirmation or ratification. A contract can be enforced against one who has an infant at the time of a contract formation if she has since gained capacity and retained benefits of the contract. The requirements are that 1. Agreement entered before capacity, 2. Capacity has since been gained, and 3. Benefit has been retained. Infants' liability for necessities. Infants are legally obligated to pay necessities such as food, clothing, and medical care. Liability is based on a quasi-contract, so infants cannot be sued for breach because there is not an enforceable contract. Statute of frauds. Are contracts subject to statute of frauds require special proof of their existence. Failure to satisfy statute of frauds requirements may result in an invalid contract. Methods of satisfying the statute of fraud are 1. Signed in writing. A writing containing the signature of the party to be charged. The party asserting the statute of fraud defense. UCC exception. Signed writing not required if 1. Both parties are merchants, and 2. The party asserting statute of frauds defense receives a signed writing memorializing the agreement and its essential terms and failed to respond within 10 days of receipt. 2. Performance may satisfy statute of frauds. In a service contract, only full performance satisfies the statute of frauds. Sale of goods contract, delivery and acceptance of goods satisfies the statute of frauds. Custom-made goods. Statute of frauds is satisfied once seller makes a substantial beginning toward the performance. Real estate, part performance by the buyer satisfies statute of frauds. If buyer has done 2 of the following 3, A, full or part payment, B, possession of the property, or C, improvements to the property. If a contract is within the statute of frauds, it must satisfy statute of frauds requirements to be valid. Contracts within the statute of frauds are 1. marriage contracts or promises made in consideration of marriage. 2. Service contracts incapable of being performed within 1 year. Statute of frauds does not apply to lifelong deals or contracts that say nothing about time for performance. Both are technically capable of performance within 1 year. 3. Land-related contracts or transfers of property interests, including leases or terms greater than 1 year. 4. Executor promises, and these are promises by executors, administrators, or who personally answer for the debts of the decedent's estate. 5. Guarantees, promises to pay the debts of another. And 6. Sale of goods of $500 or more. The following are defenses to contract formation enforcement. Illegality. Look for illegal subject matter or purpose for the contract. So illegal subject matter, contract is not enforceable. Legal subject matter but illegal purpose, contract only enforceable by one who did not know about its illegal purpose. Legality is based on existing law at the time of the contract formation. To avoid frustrating public policy, a contract may be enforced if its terms violate a policy intended to benefit a party seeking relief. Misrepresentation or fraud. False assertions, concealment, or misstatements about material facts before contract formation or performance. Contract is voidable if a party detrimentally relies on the misrepresentation. Undue influence. Contract entered into under excessive pressure by someone unduly susceptible to pressure is voidable. Duress. Wrongful act or threat that overcomes a party's free will. Physical. Contracts induced by physical duress are void. Non-physical, voidable by the coerced or threatened party. Unconscionability. Courts may refuse to enforce all or part of a contract that is unfair or oppressive to one party based on bargaining or terms. Arises with adhesion contracts, exculpatory clauses for intentional acts. Look for an absence of meaningful choice by the disadvantaged part. A contract may be unenforceable or void/voidable where there was a significant misunderstanding or mistake during contract formation. Misunderstanding is an ambiguity concerning terms of the contract. Neither party is aware of the ambiguity. No contract is formed unless both parties intended the same meaning. One party is aware of the ambiguity, meaning the contract is formed, a contract enforced according to the intention of the unaware party. For example, if A knows B misunderstands, but A remains silent, then the contract enforced according to B's understanding. Both parties aware of ambiguity, no contract formed unless both parties intended the same meaning. And then there's mutual mistake. When both parties are mistaken about the underlying factual assumption at the time of contract formation. Contract is voidable by an adversely affected party if 1. Both parties are mistaken concerning the basic assumption of fact. 2. Mistake materially affects the agreed upon exchange. And 3. Adversely affected party did not assume the risk of the mistake. Unilateral mistake. One party makes a mistake concerning the facts of an agreement, usually arises with computational errors. Unilateral mistake will not prevent contract formation. Exception is when mistaken party may void contract if mistake is material and non-mistaken party knew or should have known of the mistake.